Hi, I'm Lawrence LeBrocq, the managing partner of Garces Grabler LeBrocq, and you've been injured, and our firm now represents you. Let me tell you what the process is. First, it is a long process. Nothing in a legal field happens quickly. Initially, you're severely injured, so you're going to get all the treatment you deserve. You need to see your medical providers. We will assist you with finding medical providers if you do not have one of your own. We've been in existence over 30 years and know who the top chiropractors, physical therapists, orthopedists, neurologists, psychologists, who they are and where they're located. We will assist you in getting the medical treatment to alleviate your pain, suffering, and loss of enjoyment of life as much as the doctors can. When you're done treating, whether it's 3 months, 6 months, 18 months, we will gather all of your medical information, including your medical bills, narrative reports on how your condition progressed. We will take all of your medical records and we will submit them to the defense insurance company. We can't put this package together or submit it until your treatment is over. So the length of the case depends upon the length of the treatment in a lot of cases. Because if you treat for a year, we can't put the package together until after your treatment is over, so the doctors can write us the reports and get us all of their medical records. Once they're submitted to the insurance company, we will make a demand. The insurance company will normally make a counter offer, and that counter offer is normally very low as compared to what the reasonable value of your claim is. And here's the reason. The insurance company is going to dangle a carrot hoping you're going to take it. So if your case, and I'm going to just use round numbers, is worth $100,000, the insurance company will offer you 3. You may say, well, why would they do that? Because some people are desperate for the money and will take a much lower value than what their case is worth, just to put food on their table. After a demand is made and an offer is presented, if they're too far apart and there's no way the case is going to settle, we'll file a lawsuit. After your lawsuit is filed, there's a year of discovery. What does that mean? Well, you're going to have to answer questions called interrogatories. These are form questions that are asked in every case. So you'll have to come into the office and we will go over the questions with you and you will answer the questions. You will have to submit to defense medical exam, sometimes referred to as an independent medical exam, but there's nothing independent about it. It is the defense doctors that you have to see in order for the defense to have a chance to examine you and counter the arguments of your doctors. You'll also have to submit to a deposition. A deposition is simply a question and answer period under oath. During the deposition, the defense lawyer or lawyers will question you regarding how the injury occurred. If it was an automobile collision, they'll ask you how the collision occurred. If it was a construction accident, they'll ask you what happened in that construction accident. Trip and fall, how did you trip? All the mechanics of your injury. If it's a medical malpractice, they will ask you questions about what you remember about the procedure and all about your medical condition. Deposition normally will take approximately 2 hours. That is your opportunity for the defense to find out what your story is, to find out about you, and they're going to judge you as a witness with regard to your case. After the deposition takes place, you will have to go to an arbitration. Now remember, this is all after your medical treatment is finished, that discovery deadline of at least a year. Then you're going to get an arbitration. And an arbitration is where an attorney such as myself, I've been arbitrating for decades, with a significant amount of experience, will tell both sides what they think the value of the case is. At this time, arbitrations are generally done in the courtroom. You do not have to attend the arbitration, but may attend. At the arbitration, the arbitrator will put a percentage of liability on both parties. For example, if it's a rear-end collision, It'll be 100% on the defendant, 0 on you as the plaintiff, and then they'll give you a money award for your pain, suffering, and loss of enjoyment of life. That award is not binding. Either party can reject that award within 30 days. If either party rejects the arbitration, you're given a trial date. And that trial date is normally assigned 2 months later. But remember, trials can be adjourned by the court. There are very few judges for the thousands of lawsuits that are filed every year. So although you may get your initial court date 2 months after the arbitration, that case may not be heard for a year or 2 after. Throughout my career, I've been as high as 16 trial calls. That means the case was delayed 16 times because there were older cases in front of the case I was going to try. So at the end of the day, this process may resolve quickly, and those situations are normally when the insurance policy is very low and the injuries are very significant. But it may take up to 4 years, sometimes longer if it's a very devastating situation where the injuries are catastrophic. So remember, this process is very long. We will contact you throughout the process. You can contact us at any time, and our attorneys will return your phone call within 24 hours. Remember, our core value is to treat you like family. If you have an issue or are unhappy with anything, you can contact me, Lawrence LeBrocq, the managing partner, or the founding partner, Will Garces. We will be happy to address any of your concerns because you are the most important part of this case. It is your lawsuit. We only represent you, but we will do the best we possibly can to maximize the value of your case. That is our niche in the industry, is we prepare every case for trial in order to maximize the value. Because the only leverage we have on our side is a jury verdict. So if you have an unreasonable insurance company on the other side, or a defendant who does not want to pay you fair value for your injuries, the only choice you have to get the money from them and force them to pay is to take the case to trial. And we are trial lawyers. If you have any questions, please contact us and let GGL win for you. Thank you.